here today to talk about Senate Bill 180, the Georgia Religious Freedom Restoration Act. I appreciate your presence, and we're going to get down into some of the details. Look forward to, after a short presentation, taking some questions from you. The Georgia Religious Freedom Restoration Act, Senate Bill 180. Every Georgian should be free to worship and exercise their faith without unfair federal, state, and local government intrusion. The Georgia Religious Freedom Restoration Act protects ordinary people from unfair state and local government intrusion by exactly mirroring the bipartisan federal RFRA law that currently protects people from unfair federal government intrusion. After the federal RFRA was passed almost unanimously in 1993, the United States Supreme Court ruled that the federal RFRA only protected people from unfair federal government intrusion and would not protect people from unfair state and local government intrusion. Since then, 34 of the 50 states have adopted their own state RFRA law or seen their courts adopt state RFRA protections by judicial ruling, doing this to protect from overreach by not only federal but also from state and local governments. In 1998, State Senator Barack Obama voted for the Illinois State Religious Freedom Restoration Act statute. In 2016, Georgia passed a state RFRA law, but that included language that was far different, far in excess of the federal RFRA language that's included in Senate Bill 180. That broadly expanded statute was then vetoed by Governor Nathan Deal. In 2017, our state attorney general confirmed that without a state RFRA statute, Georgians do not have true constitutional protections for free exercise of religion, but that the government can infringe on their faith for any, quote, rational reason. In 2021, Montana and South Dakota became the 33rd and 34th states to adopt state RFRA that closely mirrored the federal RFRA balancing test framework. RFRA explained, RFRA puts the First Amendment right of free exercise of religion on the same level as the First Amendment rights of speech, assembly, and press, which all of you enjoy, by creating a balancing test to weigh a person's right to practice their faith versus the government's power to limit their actions. Under RFRA, before a government can force a person to violate their precepts of faith, it must show first a compelling governmental interest, and secondly, demonstrate that that incursion on their free exercise of faith is done in the most narrow way possible in achieving the state's interests. What does RFRA look like in real life? Courts have held, because of state RFRA law, that government could not force Mennonite owners of a Pennsylvania wood products manufacturing company to purchase and provide abortion-inducing drugs and devices for their employees. Philemon Homes, a faith-based halfway house for transitioning prisoners, was allowed to continue offering its ministry to those transitioning out of the prison system after the local city council changed the city's zoning law to attempt to shut down Philemon Homes. Florida Good Samaritan Arnold Abbott was arrested for serving meals to homeless people in a public park in Florida. Florida's state RFRA law ultimately acquitted him of all charges and required the city to change their local ordinance to accommodate the feeding of homeless people in the local park. Devout Sikh and decorated Army captain was allowed to serve his country as a captain in the United States Army wearing his articles of faith in a garrison environment with uncut hair, a beard, and his traditionally styled turban. RFRA does not determine court outcomes, but ensures that people get a fair day in court when government actions impact their faith. One thing that's important to understand is that RFRA takes a balancing test that's applied at the federal level and adopts it for the state and local level. Many of our statutes at the state level do exactly that. As we adopt them, we're looking at federal rules, federal frameworks that are exercised and have been successful around the country, and adopt those for our own. In fact, in the crafting of Senate Bill 180, the General Assembly determined that whereas the framers of the United States Constitution and the people of the state, recognizing that free exercise of religion was an inalienable right, secured the protection through the First Amendment to the United States Constitution and the Bill of Rights, and in paragraph 3 and 4 of Section 1 of Article 1 of the Constitution of the State of Georgia. Also, recognizing that in 1997, 4 years after the passage of the Federal Religious Freedom Restoration Act, in the case of City of Bourne v. Flores, the United States Supreme Court held that the compelling interest test provided for in the federal RFRA statute to protect the inalienable constitutional right of the free exercise of religion from federal government must be, as the court said, adopted by states through legislative act or by court's decision to apply to state or local government intrusion on people's basic religious rights that's enumerated in the Constitution. Therefore, the General Assembly has determined that following legislative act, Senate Bill 180 adopts the same compelling interest test, mirroring the words of the balancing test in federal statute exactly. It provided that the Religious Freedom Restoration Act will be applied in a manner to state actions and to local government actions across Georgia. What this means for us, I'll give you a couple examples. When you think about this balancing test that requires a government to demonstrate two things before infringing upon someone's rights, doesn't predetermine any outcome. That's one thing that folks need to understand. The RFRA statute is not a guaranteed win for one side or another. It's been so misframed that way. What the RFRA balancing test does is it recognizes free exercise as a full constitutional right, and with the balancing test of demonstrating a compelling governmental interest and accomplishing that interest in the least restrictive means possible allows very delicate decisions to be made that are very fact-specific to specific cases. Two of those in particular apply to a case in Texas and a case in Florida. This balancing test applied to a case of a young man a number of years ago that was a member of a Native American tribe. As an entering kindergartner, his long hair, which was his family's traditional style hair, didn't meet the standards for this Texas school district for boys in public schools. So they told him, you can't be in school with your long hair. His parents, using Texas's state RFRA statute, sued and said the state of Texas does not have a compelling governmental interest for their son to cut his hair, whereas girls didn't have to cut their hair to be in school. That compelling governmental interest test from the state RFRA statute in Texas allowed the courts to rule, you know what? There's not a compelling governmental interest for a boy to cut his hair, whereas girls don't have to cut their hair, and the family won. The boy could go to kindergarten with his long, traditionally styled hair. Likewise, however, in Florida, that test played out differently, but in a very useful and meaningful way. There was a woman who was a member of a Islamic sect that required her face to be covered, except for a very small opening for her eyes. And when she went to get her driver's license renewed at the Department of Motor Vehicles, they said, I'm sorry, we deny your license. We can't issue you a license unless you remove your face covering for purpose of a driver's license photo. Florida had a state RFRA law. She used the state RFRA law, sued the state, said, you can't make me do this. You're violating my religious rights to cover my face. And the compelling governmental interest test, however, ruled in this case, there is a compelling governmental interest to make you remove your face covering, because you can't really have a viable identification card without it. However, the second part of the test, the least restrictive means possible test, she won on. And they said, okay, we've got to make you take a license photo that shows your full face. But there's but to meet the least restrictive means possible standard, the state didn't make her take the photo by a officer out in a big open room. They allowed her to remove her face covering in a private room and have her photograph taken by a female photographer. That least restrictive means possible in the balancing test allow the compelling state interest to exist. People have to have their face photographed on a driver's license, but there's no compelling interest to make her take it in public in the open in front of a large group of people, but that a woman photographer in a room satisfied this least restrictive means possible test. This balancing test allows these very delicate, fact-specific circumstances to be reconciled and balanced in a way that makes RFRA proven again and again in vastly different contexts. Allow the compelling governmental interest to be maintained, but to allow someone's religious interest to be accommodated in the most expansive way possible, so those two interests, the government interest and the individual's interest, fits together. I share these circumstances because it's very important to understand the finesse that a RFRA statute allows us to apply in vastly different circumstances. In fact, to show you graphically where we see an issue in our state is this is not something that has zero consequence. This is not something that is that's not a significant legal question. If you can look to my right here, you can see the survey of the First Amendment rights in Georgia. Currently in Georgia, if you think about this, and I can't teach a constitutional law class here, but there's essentially 3 levels of protection that legal interests have. Things that we think about as being true, fundamental constitutional rights get what's called strict scrutiny protection. We call those first-class rights. Your freedom of press gets strict scrutiny protection. If someone wants to infringe upon the freedom of the press, you have this level of protection. And in Georgia, freedom of press is shown as being a full first-class right. Freedom of assembly, freedom of speech, full first-class rights in Georgia. What's different, though, is when the federal government ruled in 1997 in the Bourne v. Flores case that only if the states enact a state-specific statute can protections relative to state and local government exist, this test gives you only this rational basis level of protection. Now, what these rights essentially mean, and I'm simplifying a little bit here, but the strict scrutiny, this is the level of protection that an individual's interest has if it's a truly fundamental right. A statutory provision that says by law you've got to go do this it's reviewed with intermediate scrutiny. Lowest level, rational basis, simply means as long as the government has any rational reason that's not overtly discriminatory, it doesn't go after one person and says this person is being treated differently than everyone else, and we're going to almost capriciously go after them, as long as that's not the case. Any rational reason the government generates to overcome an individual's interest persists. Rational basis is really having very, very little rights of any kind. The rational basis test is where Georgia is today. In fact, if you look at the Azugbanam v. Przynski case of 2017, it was a free speech case. It ended up being a free speech case coming out of Georgia Gwinnett College. There was a young man, a West African young man, who was a student at Georgia Gwinnett, who wanted to preach the Christian gospel on campus. He was told by campus leadership that you've got to do this only here in this prescribed free speech zone. He wasn't happy about being in the free speech zone, but he went to the free speech zone dutifully. And as he was sharing his beliefs, students complained about it. In fact, Georgia Gwinnett said, you know what, even though you're in this free speech zone, based on the content of the things that you're saying, we're going to shut you down. You can't continue to do what you're doing. Young man sued. He sued on a free exercise prong and on a speech prong. And in that case from 2017, the State Attorney General of Georgia, in the amicus brief they filed and as the case played out in the courts, recognized there was a free speech interest, but the free exercise interest the young man had, in the words of the Attorney General, was very clear. Attorney General ruled, you have only rational basis protection. Any rational reason that the government has to shut down your free exercise means that you got to abide. You don't have, under our current legal and constitutional structure in Georgia, any right to free exercise beyond just rational basis. Any rational reason trumps your free exercise right. Now, what happened in that case, even though the free exercise argument ended there, the free speech issue was taken to the federal courts. In fact, it was just ruled on in June of 2022. The United States Supreme Court ruled in this case that his free speech interest had been violated, and he won the case on free speech grounds. But it was a very important ruling from our Attorney General that all you have as a Georgian is rational basis protections with respect to free exercise, because there is no state RFRA statute. So if you look at the 4 prongs of the First Amendment, would members of our press here like to see the freedom of the press where free exercise is today? Is there not an interest in Georgians having all 4 prongs of the First Amendment fully recognized as fundamental constitutional rights? That's exactly what the Religious Freedom Restoration Act does. With the passage of the Georgia Religious Freedom Restoration Act, we take the same protections individuals have at the federal level and apply it to state and local government so that this rational basis protection, which is essentially no protection at all, can mirror that of speech, press, and assembly in Georgia. To our left, also interestingly, I would share with you, there's geographic concern here. If you look to my left, you can see everything in dark green are the areas in which free exercise of religion is recognized as a first-class right. You can see the states around us. You can see here this third-class right, this rational basis test. Law-abiding citizens all across Georgia essentially, as the Attorney General said in the 2017 case, have negligible free exercise rights because the state has not enacted a statute designating this strict scrutiny standard, this balancing test that this Senate Bill 180 proposes. Now, why do we see dots of dark green in Georgia? Where do those come from? The dots of dark green you see here in Georgia, first, are our military bases because they're federal installations, and individuals' right to free exercise is governed by the federal Religious Freedom Restoration Act of 1993, and individuals on military bases have those rights. What are the dots? The dots are not federal prisons, the dots are our state prisons. Why do convicted felons doing time in our state prisons have full free exercise protection? Well, the answer is because in 2000, Congress passed a law referred to as RLUIPA. RLUIPA deals with real estate and institutionalized persons. So anybody in any prison, and it applies both to the state and local level. The RLUIPA law from 2000 says if you're institutionalized, then you have full right, you have full strict scrutiny protection for your right to free exercise. So every single state prison, all the convicted felons in our state are protected by the RLUIPA law, which does apply at the local level. So convicted felons in Georgia serving time in our prisons have full first-class protections for their right to free exercise, but law-abiding citizens like us do not. It's unambiguous, it's very clear, it's been ruled on, and taking the balancing test that the federal language has and simply applying it at the state and local level is what Senate Bill 180 does. With that, I'd be glad to take questions. Yes, sir. Well, you know, if you think back to 2016, one of the issues we saw in 16 was this issue of competing exemptions. You know, there was a so-called non-discrimination component to the 2016 bill, which carved out an entire section of potential claims that RFRA could address and solve. And that was counterbalanced on the other side by carve-outs for pastors and churches and things. It was a series of exemptions. I think the flaw in thinking that the balancing test of RFRA is not sufficient is this belief that it's going to somehow bring about some perverse end. I mean, RFRA, as I shared with you, does not bring about any guaranteed outcome for any one party in a circumstance. But it's intended to go specifically to the kinds of cases that you see in claims of discrimination, in claims of invidious discrimination, in claims of civil rights being violated, and how you fit together certain competing interests. The balancing test as it exists is intended to solve those problems and resolve them in the fact-rich, situationally specific ways that's very, very useful. When you create carve-outs to say that this entire class of people can't be, the balancing test doesn't apply to them, then the value of the balancing test is it can't be brought to bear to balance those interests. So what you end up having is, as I say, the balancing test taken as a whole runs towards and embraces those difficult circumstances and balances and resolves them in a fair way. And I can give you some specific examples of that. When we talk about exemptions that's being talked about, these entire categories can't be addressed by it, then they're sort of counterbalanced by other categories on the other or three or four different ends. They're coming from different corners. What I refer those to as sort of a barrage of exemptions trying to compete against each other. That was one of the failed. I think one of the failing flaws of the 2016 bill is that sides were competing for exemptions, and didn't let the balancing test do what it does uniquely well. And so I would caution that the best way to address this is to let the balancing test wade into the difficult circumstances that many people are contemplating. And I shared some of them yesterday. There may be a question or two about them. So I'm glad to address some of those specifically. But the balancing test is intended to weigh those competing interests in a way that makes sure that both sides of a circumstance can enjoy their rights as fully as possible to achieve the best outcome, not prejudge that one side will win or one side would lose. Yes, sir. Well, again, I would say in essence, what the 2016 bill did was tried to bring in this broader conversation about exemptions. That's really what's being talked about, having a companion bill. Those were rolled together in one bill. In fact, if you remember in 2016, there was something that was referred to as the Pastor Protection Act that was rolled into the RFRA bill, and there was a non-discrimination clause that talked about invidious discrimination. All of that was intended to somehow try to true up and modify the balancing test. Well, the balancing test is specifically intended to address those issues. I think when you think about COVID-19, one of the things we look at when you consider in a time of a pandemic. You saw states near us, Mississippi had a mayor that came in and said people in a church couldn't have church in their parking lot with individuals in their cars with their windows rolled up. Clearly, a time of a global pandemic creates a compelling governmental interest towards public safety. But when you have no burden to accommodate that interest in the least restrictive means possible, it allows, a governor in California, which is a non-RFRA state, to say, you can't sing in church. When Roman Catholics in California tried to move outside and have their meetings outside with separation, they said, you can't do this. I'm shutting you down. Well, there's no duty to accomplish someone's public safety, public health interest in the least restrictive means possible that allowed just the strong arm of government to do things that are just shocking, I would say shocking to the conscience. The mayor in Mississippi backed down. A case didn't go through the courts citing RFRA, but RFRA would have asked the question, is having people in their car with their windows rolled up, listening to their preacher on the radio, and preventing them from doing that, is that accomplishing your public health goal in the least restrictive means possible? And I don't think would have met that test. So, to your question, trying to roll in a companion framework, and I don't know what exactly they're proposing, so I wouldn't want to prejudge anything. The challenge is RFRA is intended, this balancing test is intended to move in the direction of settling and resolving these difficult circumstances. Someone asked me yesterday, I'll go to it since you guys may not ask it. They said, well, what about the case of a municipality that has an LGBTQ public accommodations ordinance that creates a public accommodations right in one jurisdiction that doesn't exist in others? Well, that's the power of RFRA. RFRA travels very well. It's a standard and a balancing test that's applied. And if you go to a jurisdiction with an elected judge that has an ordinance that specifically gives people from an LGBTQ background a public accommodation right that doesn't exist in other jurisdictions, then the compelling interest test is very easily satisfied with that interest to serve LGBTQ people in that community that's specific to that community. What that means is the compelling governmental interest in one community may be weighed differently than another community that has different community standards. I think that's a strength of RFRA. But just as that compelling governmental interest is recognized there, if that's going to come to bear on a person of faith potentially that may have an impact on them, the least restrictive means possible test still ensures that fulfilling that interest, that public accommodation interest in that area, has to be done in the least restrictive means possible. It doesn't just wipe clean someone's religious interests. It just makes sure the religious interest accommodates this compelling interest in a way that fits together and is done in the least restrictive means possible to the person of faith. So that's one of the things I talk about. RFRA travels extremely well and can be contextualized in areas based on local standards, local ordinances, in ways that I think the very diverse fabric of Georgia should recognize. I don't think we need to impose guarantees for one side or another in this. I think that the balancing test allows the complexity of specific circumstances to be brought to bear in ways that's useful, that's really uniquely useful.
You gave the example of the Grant College case.
Yep.
Which, according to the internet, students settled favorably to them. Given that
He settled it on a speech prong. He lost the free exercise prong. The free exercise prong, the Attorney General says you essentially in Georgia have only rational basis. The university easily met their rational basis standard of squashing your free exercise right, because all you have is the lowest level of protection for free exercise. He won it on a speech prong. Had it not been both a speech and a free exercise case, he would have lost on free exercise without a doubt. It was the speech thing he was able to carry up to the federal courts and win on.
So the question then is, and you've given a lot of compelling examples from out of state, are you trying to, to what extent are you solving a problem that's not that big of a problem?
I think it's not too hard to imagine circumstances in which you have local governments, local school boards telling students that student-led prayer in a public school setting is not okay. The issue of adult-led prayer is a different question, but student-led prayer in Georgia has been called into question before. You think about the circumstance of the woman with a Muslim face covering. That happened in Florida. That could have very easily happened in Georgia. All the fact patterns that happen in other states, whether it's a mayor saying that people in a pandemic can't be in cars and parking lots, that could easily happen in Georgia. I think the circumstances we share are ones that are universally understandable. They're not unique to one specific state. These are universal kinds of issues. I think the fact that I don't think we should have to prove 10, 15, 20 horrific actions that have violated people in very public and open ways to see the need to do this and to create this balancing test, particularly when you see cases, circumstances like COVID where you have a compelling governmental interest for public safety and public health, where there weren't guardrails, there weren't precedents. It was unique for people. So what framework do policymakers have to make decisions about what they can and can't do when essentially the right to free exercise is just a very, very, very minimal right in Georgia? There's really no framework for policymakers to decide what's the right balance. How would we resolve this? I mean, if you're a city attorney and you recognize citizens have, again, this strict scrutiny balancing test in place, you'd say, well, Mayor, is there a compelling governmental interest? Are we doing it in the least restrictive means possible? It informs policymakers to make wise decisions to fit together these very complex circumstances in ways that allow rights to be recognized without having to fight them in the courts. So I think it's important to see. This is and again, if we want to delve into 10, 15, 20 cases, we can begin to bring those. But I think as we look across our country, I think there's some circumstances where in Georgia, the fact that you've had a governor during the COVID pandemic, Governor Kemp was very friendly to letting folks make decisions for themselves. I can tell you if the governing philosophy in California had been in the governor's mansion in Georgia, we would have seen some very different circumstances, very different outcomes with respect to free exercise just during the COVID pandemic. Yes, sir. I'm going to let the governor's office speak for itself. I think the governor's words in his first campaign were very clear. Things like the 2016 bill passed, much broader, brought in all these other issues. He had no interest in supporting. In fact, he said he'd veto. But he said the specific federal language that specifically mirrored the federal statute, he would support. And I would just leave that to his own words. Don't quote me on what the governor said. Just use his own references from not so very long ago. I think they speak for themselves. Yes, sir.
Can you talk a little bit about the definition of person in this legislation? I know there's been questions with legislation in the past whether that refers to individuals specifically or to corporations or other entities.
Yeah, I believe it's OCGA 1, Title 1, Chapter 2 that talks about persons and natural persons. You know, corporations, entities still have that status still applies to them. This would apply both to individuals and to entities. So, yes, ma'am.
Do other states have similar laws?
34. Yep. 34 states have adopted it either by specific legislative act or the Supreme Courts have ruled as a matter of precedent with precedential authority that their constitutions undergirded this, and they have this same balancing test adopted by court order. Yes, sir.
Go back to Richard's first question. I know some of the folks who've been opposed to some of the, or have concerns about some of the ramifications of this bill have said they might be more comfortable with it, not with carve-outs like you talked about, but a statewide anti-discrimination bill on sexual orientation. Curious if that's something that you would consider if you could put people on board.
You know, we vote words on a page. I don't understand the specifics of that. And anything that I'm going to comment on that's going to have any meaning, I need to understand the words, what's being considered. You know, I do think it's a faulty premise to expect that a balancing test affects any one group of people differently than others. This is a matter of governmental actions versus people of faith. And I think the balancing test addresses specific concerns that have been raised by the LGBTQ community, I think, in a very effective way. The example I shared before about these ordinances. You know, we're a very diverse state. I think to recognize that we can have peace and be good neighbors, and have, you know, some municipalities require there be every home that's built has fire sprinklers in it, right? They're sprinkled homes, versus others don't mandate that. I think the mosaic that Georgia is mirrors the diversity of our state, and I think allows us to coexist quite nicely. I think people's interests and concerns about their community, I think it's very clear that the balancing test accommodates local differences that in a very meaningful way support the rights of individuals that live and work there. I think that framework's very good. I wouldn't want to prejudge what any statute would say. So let's look at the words on the page of what's being proposed. So. Well, I'd like to thank everybody for being with us today. I'm certainly available to take questions. I felt like this environment was helpful because a lot of the similar questions could be answered or asked and answered at once. So with that, we're concluded. Thank you.
Americans can trace their roots to every corner of the earth. We represent every race, culture, and religious faith. And while it sometimes feels like we can't agree on anything, we're united by ideals that make this diversity possible, including the notion that every individual has the right to believe, speak, and live according to their own conscience. But sometimes, even basic rights have to be balanced. For example, yelling "fire" in a crowded theater is not the same thing as free speech. So over the years, our rights have been tested in the court system, and time and again, they've been protected. But when it comes to Americans living out their faith, things have shifted out of balance. The problem began in 1990 when the Supreme Court ruled that long-held religious protections could no longer override a government policy. This shocking decision overturned decades of legal precedent and, in effect, downgraded the free exercise of religion to a second or even third-class right. Now in the courts, virtually any government policy can limit how people act out their faith, and it doesn't even require a compelling reason. Why should you care about this? Even if you aren't a religious person, the right to free exercise is really the right to live peacefully according to your conscience, especially when you're in the minority. Thankfully, both parties in Congress recognize this, and in 1993, they came together almost unanimously and passed a bill to put things back in balance. The law mandated two things. First, that the government must once again prove a truly compelling reason to limit a person's free exercise of religion. Second, that any limitations imposed by the government must be applied in the least burdensome way possible. This overwhelmingly bipartisan bill became known as the Religious Freedom Restoration Act, or RFRA. But a few years later, the Supreme Court ruled that as a federal law, RFRA only protects people from federal government policies, once again leaving people of faith vulnerable to city and state policies that force them to violate their beliefs or that prevent them from doing what their faith requires. Now, it's up to individual states to pass their own state RFRA laws to make sure people of faith are protected from all levels of government. But how does RFRA work in the real world? Here are a few examples. At a public kindergarten in Texas, a Native American boy was told he was required to cut his traditionally styled hair before he could attend school. The parent sued, appealing to the state's RFRA law, and they won. The court ruled that the government-run school did not have a compelling reason to overrule the family's religious freedom. But RFRA is not an excuse for anyone to just circumvent the law. A Muslim woman in Florida refused to remove her full-face veil for a driver's license photo, so the DMV declined to renew her license. She sued, citing Florida's RFRA law, but the court found that the government did have a compelling reason to require full-face photos. However, to enforce the law in the least burdensome way possible, the woman was allowed to have her photo taken in a private room by a female photographer. This common-sense balancing test is exactly how RFRA works. It simply provides a tool for the courts to weigh people's religious rights versus the government's duties. So what might happen in a state that doesn't have a RFRA law? In 2017, at a public university in Georgia, a student was told to stop preaching in a designated free speech zone because his words were said to be disturbing. The student has initiated a lawsuit to challenge that policy. But the state of Georgia has taken the position that the free exercise of religion is a third-class right, and therefore the school merely has to show it has a rational reason to win the case, even if the resulting burden on the student's religion is substantial. Unfortunately, misinformed people have claimed that RFRA is a discrimination law, but those same opponents cannot point to a single case of discrimination in RFRA's long legal history. Instead, RFRA is about restoring the basic human right of all Americans to peacefully live according to their own beliefs. In fact, of the 10 most business-friendly states in America, Georgia stands alone in not having RFRA's proven balancing test to resolve conflicts in a way that is fair to all. To be a true center for global commerce, Georgia needs the legal stability that passing RFRA would provide. Even convicted felons in our prison system enjoy RFRA-level religious protections that law-abiding Georgians do not. Georgia must act to join over 30 other states that have already restored the basic right to free exercise of religion. Share this video with friends and family and sign up today to urge Georgia government and business leaders to support RFRA.